Hi, my name is Moses Bradford. This is uh, take take two for a week two assignment, the Pregnancy Discrimination Act and FMLA discrimination case regarding Jamie Davis, a English instructor at Skyland Prep, and Doris Jones, the headmaster there at Skyland Prep. This case involves Jamie Davis, the instructor, English instructor there, who is pregnant and comes down with or develops a case of pre-eclampsia, which is a medical term that can affect the outcome of the pregnancy as well as the mother herself. She was giving the advice by her doctor to go on pregnancy leave immediately. Due to this request of medical leave, Dr. Jones, the headmaster at Skyline Prep, advised Mrs. Davis that she should resign due to the fact that she may be setting a poor example for the students there at Headline Prep. I was given the call by by Doris Jones, in regards to this matter, and was asked what would be the best advice as to how her and Skyline Prep should proceed. Regarding this particular matter, you have to keep in mind that under the Pregnancy Discrimination Act, it describes, which is based on pregnancy, it comes to any aspect of employment, including hiring, firing, job assignments, promotions, layoff, training, and fringe benefits, such as leave, health insurance, and other terms or conditions of employment. Now, under the Pregnancy Discrimination Act, if a woman is temporarily unable to perform her job due to medical conditions related to the pregnancy or childbirth, the employer or any other covered entity must treat her in the same way as they would treat any other temporarily disabled employee. For example, if employer may have to provide light duty or alternative assignments, disability leave, or unpaid leave to pregnant employees if it does so for other temporarily disabled employees. Now, in regards to the PDA, we also have the FMLA Act, which is a Family and Medical Leave Act, which provides certain employees up to 12 weeks of unpaid job protected leave per year. It also requires that they group health benefits maintained during this time. This was created for pretty much this type of situation, for the birth and care of the newborn child of an employee, and things of that nature. In Skyline Prep's matter, she would be protected, meaning Instructor Davis would be protected under both the PDA and the FMLA Act. And I have advised that to Mrs. Jones. I've also advised Mrs. Jones that the actions that the Skyline Prep has currently taken would not suit well with courts, and it would be best to reconsider the situations as fast as possible, giving Mrs. Davis her time off needed as up to 12 weeks or more if agreed upon. And with that said, I would close this video with saying that in regards to matters like this, you have to look out for those who need it. And in this case, Instructor Davis needed it. And it could have been easy for Mrs. Jones to look this up, but I'm glad she did call us to get this matter, understood correctly. So with that being said, I'm closing out. Thank you.